All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Please be seated. Well, I understand we're finally ready to proceed. So, Madam Clerk, will you please call the case?
Case number SC 2024-0066, John C. Brown, v. State of Alabama, ex rel. Deanna Ceasor, as informant. Arguing for the appellant, the Honorable Scott Morrow. And arguing for the appellee, the Honorable Wayman Newton.
Mr. Morrow, you may start.
Thank you, Your Honor. May it please the court, and let me first apologize for my tardiness. And I apologize to the court and to all of that are present here. I hope that my tardiness does not reflect on my client or this case. I never thought as a young man growing up in New Jersey that I would be standing in the Alabama Supreme Court hall arguing for a case, such an important case that could possibly affect the whole state. And I'm proud to be doing that, and I'm glad to be here. Let me first say broadly that this case, the justiciable issue in this case, from what I've read and what the record reflects, I think is a issue between the City Council of Tarrant and the Mayor of Tarrant. And as you well know, the Mayor of Tarrant, the Honorable Wayman Newton, is actually arguing the case for the relator, Deanna Ceasor. We don't know much about Deanna Ceasor, as this is a quo warranto case that she is the relator and is being represented by the mayor in the name of the state. And I know
so you would agree with me that that you think the mayor is the real party in interest here?
I do agree with you, and I was just about to go into that, Your Honor. I was going to, the record reflects, and when you read all of the arguments at the beginning of the TRO, the date of talking about whether the mayor should be actually representing the agency of the city, you see that Wayne Morse was doing most of the argument, and he is the counsel for the city council. Judge Ballard recognized later in the case that there was two different entities, which would be the mayor versus the city council. In a Class 7 municipality, I would disagree with that. I would say that the mayor and the council together create that entity. So here we are with a quo warranto, and I know from Hudson v. Ivey, from Griggers v. Douglas, I know those parties. I know those cases. I've read those cases. From Burke, that this panel, while Burke and Douglas have to deal with procedural problems in the quo warranto application, I think Hudson v. Ivey gets to the main meat of this case. Is this a quo warranto? And your questions 5-4 concurring and not concurring on the questions posed to us to be ready to answer. I think this case is a declaratory judgment case based on the reading of the code, because this is a question of the mayor questioning the validity of the law that the city council passed, the ordinance establishing a city manager.
Well, let me break this down slowly. So you would agree with me that quo warranto can be used to challenge the existence of an office, correct?
I do agree, because that's what this ruling was in Hudson v. Ivey. I agree with that. And the amicus curiae, Wayne Morse, they agree with that as well, Your Honor.
So you believe the mayor and the city council are both indispensable parties too?
There's 100% the city council is an indispensable party and should have not only been allowed to intervene, which was only a question of the certificate of service not having an address or phone number, but they should have been made to intervene by Judge Ballard.
But you didn't raise that as a defense. in your answer, did you?
Yes, we did. I believe we did raise that.
I don't believe it's in your answer, and you didn't file a motion either, did you?
At the appeal level, Judge, I was not involved in the actual case. It was the Blankenships, Patrice and her husband represented John Brown during the meat of the case. I came on board at the appellate level.
But there was no motion filed by your side to add indispensable parties, right?
By our side, I would say there was an argument, but I will say that I don't remember a motion. There was a motion by the city to do so, which was denied because Judge Ballard denied that.
So if we're missing a real party, if the mayor is the real party in interest and there are indispensable parties that are missing, is it your position that we should remand this case to allow an amendment in for all of those parties that are missing?
I would say yes. That's absolutely one of the ways that this case can be resolved by this court, by 19A, sending it back to Judge Ballard to allow the city to actually argue the case.
Do you understand the difference between what a necessary party is versus an indispensable party?
Yes, that relief cannot be granted without their participation.
And so is a city council a necessary party or an indispensable party?
They are an indispensable party because they are the ones who came up with the ordinance.
So what would the city council, if they're represented, possibly bring to this appeal that we don't already have? I mean, what would adding them add to this that somehow we're missing by not having them present in either the litigation down below or here?
I think that they would be able to argue the construction of the ordinance, and they would be able to rebut the assertion by the relator via the attorney that it was an invalid, unconstitutional ordinance.
Isn't this just really a question of law? I mean, can't we, do we need those parties here if this is just a pure question of law? And as you said earlier, you think it's more of a declaratory judgment?
Well, I think I agree with you. It is a question of law, the facts and the law to be applied. But I think that leaving Mr. Brown as just somebody who was hired by the city council is missing important information that Judge Ballard needed to hear.
It's a question of law, isn't it? If they did the right thing or didn't do the right thing, did they follow the law or did they not follow the law? Isn't that just a question of law? I mean, don't we have a statute on this? Statutes on this?
Well, I think it could be a question of law, but I still think under 19A that you have to have the party there to argue. I think under the 19A and subject matter jurisdiction, that unless you have the indispensable party there, you don't have subject matter jurisdiction. I think John Brown was not the proper party to be named.
You would agree, picking up on what Justice Bryan said, you would agree there's no dispute of fact in this case.
I agree with that, Your Honor. There is no dispute of fact. An ordinance was established for whatever reason. I don't think it really matters. The ordinance was valid under 1143-20.
So the city council did have the authority to establish that ordinance?
Yes, under 1143-20. And that's part of what this panel, I think, struggles with is 1143-20 and 1143A, as the mayor has argued for the relator, and how the City Manager Act, how those two laws, one more modern than the other, can be reconciled. And I think under 1143-20, it says all municipalities may employ and pass an ordinance regarding a city manager. And the city did that. But I represent John Brown, so that's why I think you need the city in so they can argue for their action.
Just to be clear, that ordinance stripped the mayor of all his powers, didn't it?
Well, it purportedly did, but the 1143-20 also has language in there that says the city council may give to the city manager the powers as they desire. And with the city council being the appointing authority, the legislative authority, of which the mayor would have a vote, they're allowed to give those powers as they see fit.
Well, 1143-81 says the mayor shall be the chief executive officer and shall have general supervision and control of all other officers and affairs of the city, correct?
I'm glad you brought that up. You are correct, but you have to read further, Judge.
Go ahead. What am I not reading?
Or as otherwise provided for by law. That is the key factor. In Ballard at the time believed that he was protecting, I think, the integrity of the mayor's office from being usurped. I believe he thought that. But as I've been involved with the police chief, the fire chief, as otherwise provided for by law has meaning. And under state code, and we've done this with the police department, fire department, other entities in the city of Tarrant, as otherwise provided for by law, allows under 114355 with the police for the council to see the state code and to file a municipal ordinance in accordance with that state code. And that's what they've done. They've taken 114320 as otherwise provided for by law, and they've established that city manager. And so I think that's what's missing.
We have a whole code section, right? A whole article of the code that deals with changing your form of government to a city manager form of government, correct?
You do, yes.
And under 43A, under that section, you have to have a referendum to do that, right?
Yes.
Mr. Morrow, your time has expired. I will allow this question to continue and you to answer.
So you've effectively changed the form of government here without having a referendum, haven't you?
No.
You took the power away from the mayor and you gave it to the manager. How is that not changing the form of government?
Because it still complies with 114320.
Thank you, Mr. Morrow. Mr. Morrow has reserved the remainder of his time for a response. Mr. Newton?
Good morning. Chief Justice Parker, Associate Justices, may it please the court. My name is Wayman Newton, and I represent the Appellee, Deanna Ceasor. And although I do currently sit as the mayor of Tarrant, I appear before you today solely in my individual capacity as a duly licensed member of the Alabama State Bar, in which I represent Ms. Ceasor in this matter. I will direct my remarks to address the two key questions presented by this court in its September the 2nd order. Namely, one, can the remedy of quo warranto be used to challenge the legal existence of a public office, or is it limited to testing an individual's right to hold that office? And number two, how should this court characterize the nature of Deanna Ceasor's challenge in this case? It is our position that this case was properly filed and it should be properly characterized as a quo warranto action. Alabama law has long established that any challenge made to a person's right or ability to hold a public office must proceed under a quo warranto action. This principle has been the law for the past century, and it was reaffirmed just 75 days prior to the filing of this action. On March 24th, 2023, this court gave the opinion in Hudson v. Ivey, SC 2022-0836. And in that opinion, this court affirmed and made it very clear that all action seeking to remove someone from office for unlawfully holding such office can only proceed as a quo warranto. In that particular case, the petitioner was attempting to challenge the governor, as well as Mr. Chief Justice,
Who recused from the case.
As well as the judge that was appointed in the seat. The seat was removed from Jefferson County and it was sent to Madison County. And in that opinion, Justice Seward, you actually cited a case that actually answers the very question that was presented in that September the 2nd order. And I was a bit puzzled because I remember reading this case. Justice Stewart, you cited Corpory v. Tallapoosa County. In that case said, and I quote, "It is fully settled in this state that statutory quo warranto is the appropriate remedy to test the existence of a de jure office, the same as to oust a usurper intruding into an office, and in adjudicating the existence of such office vel none. The court may determine the constitutionality of the act purporting to create the same." This language and this legal framework is actually in keeping with earlier cases going back to the 1800s, in which a quo warranto was the exclusive remedy one could use to challenge a person's ability to hold office.
So I want to direct you in a different direction. You made a pretty good argument there. I'll give you that. Pretty good argument. Let me talk about whether you're the real party in interest or not. You yourself, the real party in interest. If we were to decide that you were the real party in interest, would you suggest that we remand the case so you could be amended into the case as the plaintiff?
No, Your Honor. If you look at the quo warranto statute, section 66591, it says an action may be commenced in the name of the state against the party offending in the following cases. This statute, the legislature has made it clear that it has conferred standing for a person if they believe that someone is unlawfully occupying or usurping a public office in the state of Alabama. The legislature has shown their intentions that a person has standing to bring suit. And my client, Ms. Ceasor, who was a resident of the city of Tarrant when this was filed, not only was she a resident, she was a taxpayer. Not only was she a taxpayer, she was an elector. She had standing. This court, in the cases that I've briefed, has found that a person has standing as a taxpayer to bring an action if there's a situation or any type of circumstances that damages them.
So it didn't change the question of whether someone's an indispensable party, correct? Aren't you
No.
an indispensable party? They stripped you of all your powers. How are you not indispensable here?
Well, this is again, this particular code section, the statute, it's pretty clear that a person has standing, anyone has standing to bring this suit. And I chose not to actually sue, get involved. And I will be honest with the court. I think this is probably the only time that I can actually say this before the Alabama Supreme Court, is that I chose not to pursue this for political reasons. I am the mayor, and as the mayor, it would have meant that I would have had to sue my city council. And even though I would have been responsible for paying my own legal fees, the council was going to actually use city dollars. And so I did not want that. And so as an individual, as a mayor, I had the right to decide whether or not I wanted to participate. And
So
the
it's-
fact
let,
that
let me let me be very blunt here, okay? I'm concerned that this case might be moot because your client has moved out of the city. I don't see how it's not moot, but let's not go there right now. I think it's moot. So the question is, how do we proceed if your client no longer has an interest? And I look at it and I say, you look indispensable. The city council looks indispensable. If we wanted to remand this case and give you an opportunity to amend in yourself, are you willing to do that, or you just want us to dismiss it as being moot? I mean, I told you I was going to be frank.
Well, if it came down to that, in the interest of justice, in the interest of making sure that the law is followed, I would prefer that you remanded with me actually joining the case. But with respect to your position that this is a moot issue, as I briefed in my brief, the court in the Pharmacia v. Scruggs case, it talked about the issue of mootness. What the appellant attempted to do was it appeared as though they confused mootness with standing. My client had the standing to bring this case because she lived in Tarrant. And 5 months after this case was filed, she had to move to find affordable housing. Now, her moving to find affordable housing, that did not make this case moot because she still had a legitimate interest in pursuing this. And that legitimate interest is the fact that she voted in the 2020 municipal election. She was a duly elector, and she did vote, which was evident in her deposition. But more so than that, this court has found in the two cases that I presented to the court in my brief, Morrow v. Bentley and the Claiborne County School Board versus Payne, it's found that a person has standing to sue if their vote is nullified. In the case of Morrow, that case involved a legislature having standing to sue because I believe the governor did not do something. And so the legislature said that, or believed that his case, that his vote was nullified. And this court actually affirmed that. It said that you have a right.
Legislator was still a legislator, right?
Yes.
In the Claiborne County case, they were still a trustee. They had not ceased being a trustee.
Correct.
And so here, your client has ceased being a resident of Tarrant. They have no interest in Tarrant going forward.
Well, no. This court has stated, as I again briefed, put in my brief, that the right to vote, the right to be heard, I believe is the term of art that the court used, is a fundamental right. And it's enshrined in both the U.S. Constitution and the Alabama Constitution. And so just because she does not live in Tarrant, when she went to the polls to vote, that vote meant something. And for a council to decide that they do not like how that election went, that doesn't give them the right to actually go and totally nullify the election and nullify her vote. And so when you say that by virtue of her moving, she no longer had an interest in Tarrant, I respectfully disagree with that because, again, voting is a fundamental right, and it's enshrined in both the Alabama Constitution and the U.S. Constitution.
But if she moves, well, let's just say she moves out of the country, are you still going to make the same argument that she has an interest in what goes on in Tarrant?
She has an interest in her vote actually mattering.
So then, in your view, standing in this case is determined at the time the suit is filed based on actions that she took that preserved a right that she had because she cared who the mayor was, and could she lose standing anyway? Or?
So it's my understanding, and as I briefed, included in my brief, that standing is a snapshot at the time that the suit was filed. And then the issue of mootness is
the suit would relate back to the fact that she voted. That's the action that gives her the ability to pursue this. She voted, and that action of her voting is the right that we're preserving by giving her the ability to go and challenge what the city council did.
Yes, Your Honor.
I'm going to take you in a different direction, provided you can get over this first hurdle and get to the ordinance and whether or not it was properly handled. And also, I'm just curious your thoughts on whether 114320, which you acknowledge is still valid, but is it overly broad, or is it in conflict with other statutes that provide for the duties of the office of mayor?
It's in direct conflict with other statutes, namely being 114381, which states that the mayor is the chief executive officer of the municipality. But more so than that, with the 1143A, the Council Manager Act of 1982. While 114320 deals with the city manager, and 1143A also deals with the city manager. This court has espoused when it comes to statutory construction and statutory interpretation that where you have two conflicting statutes, that you're responsible for actually reading those two statutes together such that that they have harmony. In addition to that, both statutes has to have a legal effect. It also should be noted that when the legislature takes an action, if they pass a law or pass a statute, that at the time of them passing that statute or that code section, that they're well aware of all of the existing codes and statutes. And so when you take that and you actually look at the Council Manager Act of 1982, the first thing that it actually says is that that particular code supersedes all prior inconsistent laws. And so what the appellant wants this court to do is to actually create a conflict where there really isn't, because the legislature has already given you instructions on how you should proceed with respect to interpreting 114320 with 1143A. They've explicitly stated that where there's a conflict with anything that's inconsistent with the 1143A, all prior laws should be superseded, meaning that 114320 is subject to all of the requirements, the referendum requirements, the petition requirements found in the Council Manager Act. Because if that wasn't the case, then the whole Council Manager Act of 81 is pointless. Why would you choose to actually go and get the petition signed and spend all the money of having a municipal election when you simply could just pass an ordinance under 114320 and change the form of government? And I'm kind of upset that Justice Mitchell wasn't able to be here because
Let me intervene on that because I failed to mention this. Justice Mitchell is out of state to speak to a college, but he is participating remotely.
okay.
So if you hear a disembodied voice asking a question, that would be just
Well, I was just going to say, I know that Justice Mitchell, the city that he lives in, 2 weeks ago, they actually had a vote on this very subject in terms of changing the form of government to a Council Manager Act. Now, the city of Homewood could have just as easily decided that they wanted to just simply pass an ordinance and a resolution and change the form of government. But I would suspect if you know that a Supreme Court justice lives in your city, you want to follow the law and you want to make sure that everyone has the ability and the right to participate.
So those are what procedures exactly? Is that what you're saying? Basically, there was no referendum. Those are the procedures that were
The procedures.
and so in
There has to be a petition of 10% of the voters who voted in the last election. That petition has to be certified by the judge of probate. Once that petition is certified by the judge of probate, then there's to be a municipal election within 90 days. Another thing that's actually very particular about the Council Manager Act, Section 1143A7, it actually provides a time frame for if there's a change in government, when that change can actually take place, which goes back to what I was saying earlier concerning my client's vote being nullified, because the legislature has already said that if there's a change in the form of government, that change can only occur during the next term.
So those protections are put in place to avoid a small group of people, i.e. the city council, from basically nullifying a municipal election.
Correct.
And that's the protection, the scales.
Yes, Your Honor.
So I'm interested, assuming that I think there's a procedural problem here, but that I agree with you on the merits of the case. Can I go with what Justice Bryan was suggesting earlier, which is there's no factual dispute here. This is all just a question of law. Can I just get to the merits of that question and ignore these indispensable party mootness kind of issues?
Well, yes. And the reason why you can actually do that is with respect to the city council, they actually were a party to this. They filed a temporary motion. The judge temporarily allowed them to participate in the very first hearing. And then the judge ordered them to file a notice of appearance. And in that notice, that notice to intervene. The council, for whatever reason, they failed to actually follow the rules, and so the judge dismissed it without prejudice, meaning they could have simply corrected the motion that they filed, and they would have been granted the ability to intervene.
Was there a particular reason that you didn't add them to the case at the beginning?
Well, again, looking at the statute, it says an action may be commenced in the name of the state against the party offending the following cases.
So let me ask you what I ask of counsel for the appellate is, so what would the city council's participation in this case add? I mean, it's not a factual dispute. It's basically a legal issue of can or can't they do it. I mean, how does their participation somehow detract from our ability to issue a judgment?
It doesn't. They had the ability to participate. They attempted to participate, but they chose not to pursue it. And as you stated before, this is just a pure matter of law. Did they have the authority to change the form of government without fully following the Council Manager Act of 82? So. That being said, I would like to thank the court for allowing us the opportunity to come before you. As I did state in my brief, that we need direction. This is a problem that not only is prevalent in Tarrant, it's prevalent in all cities. Vestavia, Montgomery, Mobile. There needs to be some type of clarification in terms of how city councils and mayors can interact.
And
there
just
also needs-
right now, you're currently the mayor, and the city manager doesn't have any of these powers. He's been taken out of office because of you're winning the case.
Well, glad you brought that up. As of 2 weeks ago, the city council.
You may continue.
As of 2 weeks ago, the city council passed a resolution. Even though they know that he lost at the trial level, they passed a resolution where they're attempting to pay him all of his back pay, going back to the time that the judge actually rendered the order, saying that the ordinance that they passed.
But you're running the city right now,
Correct. Yes.
And your term runs out when?
August of 2025. No, I'm sorry, November of 2025.
Okay, thank you.
This took place, I'm going to refer to you, I guess, in the third party. So when did this action take place in terms of the term of the mayor?
So the term of the mayor, I took office in November of 2020.
Let's not use you because really this is about the office. It's not about you.
Sorry. The current term that the city is in, it started on the first Monday of November of 2020. And the state legislature decided that they wanted to add an additional year. So rather than the term actually ending in November of 2024, it's been extended to November of 2025.
And this action, when did it begin?
This action began, this was filed in June of 2023.
So 3 years into the mayor's term. Thank you.
Counsel, thank you.
Thank you so much.
Morrow, you're closing.
I have 10 minutes. I want to briefly say, in answer to Your Honor's question, it's because of Douglas v. Griggers as to why, if there's a procedural flaw, you can't get to the merits because you've done it before, I think. And in the analysis on page 3 of that case, we find this issue dispositive. Therefore, we do not address Douglas's remaining arguments and express no opinion regarding the issues they raise. So that's why, because there's a procedural error, it can be remanded back without getting to the merits. The quo warranto versus,
Excuse me. What was the name of that case? 'Cause I don't see it.
that is Nicholas Douglas v. Gregory Griggers, and that's CV 21900013, Supreme Court case number 2023-0259.
That's not in your brief, though, is it?
May not be, Judge.
It's not in your brief.
I want to speak at least to the declaratory judgment aspect of it, I think, because it says,
I'm sorry, could you give that site again? Because I was looking to see if it was it within your brief. So what was the site?
the site, I just have it here as Supreme Court case number 2023-0259. Douglas v. Griggers, appeal from Sumter Circuit Court,
Thank you.
decided March 29th of 2024.
Thank you.
I think we have to go beyond 114320 for that question about whether it was, if we get to the merits, because when you look at 114321, that outlines the duties of a city manager. And as I've already stated, in 114321, because it says, and it deals with 114381 on what is the duties of a city manager and can they, do the police department or the fire department. It speaks to that. But further on down in chapter 13 or number 13 under 114321, to perform such other duties as may be prescribed by law or by ordinance or resolution by the governing body. The governing body is the city councilors and the mayor. And so if they decide to, whatever duties they want to give, then they give them. And nobody's invalidated 114320 or 21.
Well, Chapter 43A, which is the one, the Council Manager Act, says that it, quote, supersedes, quote, all of the laws on this topic, right?
It does say that, yes.
So if we're trying to decide if the city manager is properly appointed, we need to look at the Chapter 43A.
But in conjunction with 4320, I think it's well established that any municipality in the state of Alabama can establish a city manager under 114320.
Why would the legislature write an act that says, I've got to follow all these other matters, such as I've got to get a petition, 10%, I believe is what I heard, that's got to be gotten in the last election, of the electors of the last election, plus all the notices, all that stuff that's got to go in with it. And then you got to vote on it. You got to have a referendum. Why would I do all that if I can just go back to, 4120?
Yes, sir, because 4320, because you actually want to change your form of government. That is a choice. Tarrant did not want to change their form of government. They've got their counselors and they have the mayor.
The council people, and you want to have a mayor and you want a city manager? Is that what you're telling me?
Because you
Yeah, that's
have
been
taken away,
done. Mountain Brook has done it. Other cities have done it. Yes, sir.
but you've taken away all the powers of the mayor.
Well, there's nothing that says that you can't, the governing body can give the city manager the powers that they desire under 114321.
Tell me again why you don't have to go through all the ramifications of 43A. I mean, such as the petitions and all that stuff.
Why? Because you don't want to change your form of government. You don't want to reduce the number of counselors. You don't want, because in 1143A, it talks about either 4 or 6, or there's a certain number of councils. You're actually changing, gerrymandering, whatever you want to do with who's voting for the council, and all of that. So they didn't want to do any of that. They wanted to maintain their current form of government, but establish a city manager with the duties under which they decide.
But you don't think that taking away the powers of the mayor is changing a form of government? Because basically the king has no clothes.
No, I do not think that. If it's a law that allows it, then they can
Law
do
that
it.
allows it with procedures in place that must be followed.
Only if you're going under 1143A. So I think that, and this is the question 5-4 for the court. At what point does the court say 1143-20 and 21 are invalidated, and you always must change your form of government to have a city manager?
I guess the issue then maybe is to understand what is the difference in the authority that a city manager has versus a mayor. I mean, are they complementary, or how does that work?
Well,
in
city
the scenario
manager
that you-
generally does do the duties of a mayor generally, and it's up to the governing body to decide what that may be.
And so then is the city council, in your opinion, then the ultimate arbiter of who has these responsibilities?
Always a city council in the size of Tarrant, a Class 7 municipality, is the policymaker. The mayor implements policy. He's part of the vote on the policy making. But if that body decides the policy is I want a city manager, and it's up to the mayor to do whatever the governing body elects to do. And that's part of the problem here. And you say the emperor has no clothes. I'm glad you use the term emperor, because that's, I have great esteem for Mr. Newton. He's a very well-educated, excellent
Mr.
attorney,
Newton.
but he is not an emperor.
It's the office. It's not about the individual. It's the office.
And I would agree with you that no mayor may be an emperor. And so the city council felt compelled, and you see it, it's in the ordinance itself in the preamble, is that they're not getting along, and they wanted to have a little more consistency in the way that the employees were being dealt with. And if I may move on, if there's other question, I think I just have a minute or two. I wanted to just briefly talk about at least the indispensable parties argument that I think is dispositive, and I would direct you to the hearing on June 20th of 2023, which is the TRO hearing, and why the court itself, ex mero motu, should have put the city in. And even the court says on page 13 of that particular transcript, I don't think it is independent of the city council because your lawsuit has called into question the legality of the creation of the office as well as the legality of the appointment of Mr. Brown. And the creation of the office was not by Mr. Brown. It was a creation by the city council. And I think that under those circumstances, the right thing for me to do is order the intervention. And so that's what he had said, but he didn't do it. And I love Judge Ballard. He's an excellent judge. I go in front of him often, and he's trying to struggle with this as perhaps you have. But he chose not to order the intervention of the city. And they're
just to be clear, though, you're representing the city manager, right?
I do.
Who got hired by the city council.
And that's all he did was.
And he has the chief executive role now for the city. That's what they want him to have, right?
Well, the city manager has no clothes.
And who's paying for your fees? It's the city council, right?
Well, yes, they are. They have paid for my fees, but I do not. Mr. Morse and Mr. Waldrop represent the city council. But I think Mr. Brown, justice would not be served to have Mr. Brown, without the city involved in the argument, to stand as a loser in this case when all he did was accept a position. And I understand the opinion in Hudson v. Ivey, where that's kind of what this court came to the conclusion. But I think that's not justice to say just by taking a position creates a liability on you, because he's subject to having to pay the attorney's fees of the relator. And I think remand back with the city council is the proper thing to do.
If the city here sits on their rights and they don't intervene or they don't file the appropriate things, how can they then somehow complain that they weren't involved in the case and they shouldn't be subject to the judgment of a court when they had an opportunity to intervene or do any number of things? And it sounds like they chose not to for whatever reason. We're going to hold the court at fault for the city council not doing what they should do to be an active party, and then say, oh, we can't do anything because they're not here?
Mr. Morrow, your time has expired, but I will allow you to respond to Justice Seller's question.
And to answer that, Judge, I don't know what the city council is complaining about, but John Brown's complaining. John Brown is the one that's saying, hey, wait a minute. All I did was take a job. The city council should be here arguing this case. And John Brown is not the proper party. It's the city council. That's why it's a declaratory judgment. And under that declaratory judgment code and state code, this is an ordinance complaint that the mayor has against the city council. This is not a quo warranto action that is appropriately before this court.
Thank you.
Your
Thank you, Ms. Morrow. We thank counsel for both sides for your arguments, and the court will now take this case under advisement. And with that, we stand in adjournment.
All rise. The court is adjourned.